very warm good evening to everyone. Our guests, Professor Gary Bond and Mr. Kunal Vajani, Professor Dr. Rajesh Bahuguna, Dean of Law College Dehradun and Vice Chancellor Uttaranchal University, Professor Dr. Poonam Rawat, Chairperson of the Moot Court Society and Principal Law College Dehradun, the organizers of the Moot Court Society and the participants of today's lecture from across the world. We have gathered here today virtually to learn about a rapidly growing field of law, which is international commercial arbitration, with the leading minds of arbitration in the world. Today is the third lecture in Law College Dehradun's Arbitration Week, and the subject of today's discourse is international commercial arbitration, arbitrating in the pandemic and beyond. Without taking further time, I would like to request our Honorable Vice Chancellor, sir, to kindly inaugurate the session and welcome the guests.
Thank you, Ms. Anna. On the occasion of this lecture series on international commercial arbitration, present today keynote speaker, Professor Gary B. Bond and Mr. Kunal Vajani, Principal of Law College Dehradun, Professor Poonam Rawat, President of LCD-MCET, Moot Court Society of Law College Dehradun, Ms. Anna Anupriya, its convener, Mr. Rahul Kumar, and all the office bearer of Moot Court Society. I'm taking this privilege to welcome you along with all the participants from this university and all the other universities in India and abroad. You all are welcome. Ladies and gentlemen, Law College Dehradun Moot Court Society, along with different student bodies of Uttaranchal University, are regularly organizing webinars and workshops at national and international level. And let me tell you, I have observed that during this period, series of webinars have taken place, series of lecture series and talk have taken place, particularly on alternative dispute resolution system, sometime on arbitration, even in arbitration, on domestic arbitration, international commercial arbitration, sometime to take the seat, sometime for the venue, sometime for the procedure, whether it is fast track arbitration, ad hoc arbitration, or institutional arbitration. I understand that almost all the factors have been touched, and eminent speakers from the globe have spoken on this platform. And today, on the International Commercial Arbitration Practicum, arbitrating in the pandemic and beyond, we have with us Professor Gray B. Bond. And when you talk about Professor Bond, the chair of International Arbitration Practice Group, is widely regarded as the world's preeminent authority on international commercial arbitration and international litigation. He has been ranked and designated by the innumerable institutions and has received numerous awards for his services to the legal community, including Advocate of the Year 2010, 2018, James Wilson Award, and 2012, London International Arbitration Lawyer, and the 2019, London Arbitration and Mediation Lawyer of the Year. He has participated in more than 600 international arbitrations. He also sits as arbitrator and has served in more than 175 institutional and ad hoc arbitrations. Professor Bond is an honorary professor of law at 2 universities and has taught at prestigious law schools, including the Harvard Law School. He is a member of numerous international institutions. Most prominently, he is the president of SIAC Court of Arbitration. Professor Bond has published a number of leading works on international arbitration, etc., including the international commercial arbitration, the leading treatise in the field. He has also authored 8 other books on international arbitration and on the contemporary on international civil litigation in United States courts, the leading on the subjects. So, ladies and gentlemen, with this profile, I'm taking this privilege to welcome you, Professor Gary Bond, on the behalf of Uttaranchal University, on the behalf of Moot Court Society, and also on the behalf of Land of God, Uttarakhand in India. You are most welcome. Ladies and gentlemen, we have another keynote speaker, Mr. Kunal Vajani. Mr. Kunal Vajani is a leading dispute resolution practitioner and had the chamber, BlackRobe Chambers, New Delhi. He received his law degree from GLC Mumbai and master's from Harvard Law School. Kunal is also qualified as a solicitor, Supreme Court of England and Wales. Kunal also holds the distinction of being the court member India, ICC International Court of Arbitration, Paris, as well as the Standing Council, South Delhi Municipal Corporation. Kunal specializes in litigation and arbitration, with his practice ranging across a wide spectrum of civil, criminal, and company matters. Kunal has also been appointed as an arbitrator, sole and 3-member tribunals in several institutional, ad hoc, domestic, as well as international commercial arbitration. Kunal has vast experience in many landmark, ad hoc, as well as institutional arbitration in the field of business, partnership, disputes, among other things. Kunal has been reported as a recognized practitioner by Chamber and Partner Asian Pacific for the year 2012 to 2020 and Global for the year 2019 and 2020. With this profile, again I am taking this privilege to welcome Mr. Kunal Vajani on the behalf of Law College Dehradun, Uttaranchal University. And at the same time, both the experts, Mr. Kunal as well as Professor Gary Bond, I'm also inviting you in advance. Unfortunately, this is the period when we cannot meet physically. But now during this period, which I say that we have learned something and we have made use of this period, and we have come across series of scholars and eminent personality like you both. And we have decided that we welcome them physically as and when the situation permits. So please accept my invitation, Professor Gary Bond and Mr. Kunal Vajani. So now not taking much of the time, and one thing I would like to send my note of appreciation to the Moot Court Society of Law College Dehradun, its chairperson, Professor Poonam Rawat, and today's host, Miss Anna PRIYA, sitting before me, and their entire team, Rahul and all. You all need appreciation. All the blessings are with you. Best of luck for this event and the events you have scheduled in future. Thank you. Thank you so much. Over to Anna.
Thank you very much, sir. Now, without further delay, I would request Mr. Kunal Vajani for delivering the guest address for today.
Thank you, Professor Bahuguna, and the entire Moot Court Society of the Uttarakhand University, as well as the Law College Dehradun, for having Professor Bond and myself this afternoon. Indeed a pleasure, and I think I would not call myself as any address. I am going to take this discretion of having only point out the entire platform or give just brief remarks, because it is very rare that the students get an opportunity to have Professor Gary Bond. It is this pandemic times which is giving them this opportunity to have Professor Bond with them. And I don't want to be between the students and Professor Bond. A gentleman from whom I have, or whose treatise has been my mentorship in the absence of his personal coaching. So I certainly also am privileged to see him on screen delivering his first lecture to me post his treatise, which I have read in entirety. As regards the topic of the day, future of arbitration is bright, but because the future of litigation is not. This is what my other mentor in India, Fali S. Nariman, said at an address of the Delhi International Arbitration Center, which is hosted by the Delhi High Court. And which is true. We have seen that in the pandemic era, which is still ongoing, both in the jurisdiction where Professor Bond is, or the jurisdiction where each of us in India are, challenges for approaching the court, challenges of going to our offices were tremendous. However, what we all saw was, despite these restrictions, that the institutions which are the backbone of the international commercial arbitration, be it the ICC court or the SISC court, both of which each of us represent. I represent the ICC court. Professor Bond is at the helm of affairs of the SISC court. He is the president. They in a jiffy and without batting an eyelid came up with the guidance note and set the ball rolling for the purposes of ensuring that the dispute resolution mechanism, which is found to be an effective alternative dispute mechanism, is in motion. The guidance notes came forward by the ICC court and SISC court, which overcame these major challenges of either having emergent reliefs, either having emergent tribunals, or also the restrictions in terms of how you could refer to the documents or move forward. The new normal, which came out in the pandemic era, seems to have now set the tone for the new normal of the future. The various challenges which we also see now in terms of the international movement restrictions are now overcome by the manner in which each of us are meeting today. Whoever thought that we would have Professor Bond address each of us over a screen, sitting in Singapore or whichever jurisdiction that he is living in presently, and delivering this beautiful address. It was always a dream to get an entry in his diary and have him physically come to India. But this is this new normal which brings us closer, faster, and more effective. This is this new normal which also seems to be a time-effective position where the proceedings would be able to be conducted sans the entire travel trouble, sans the entire logistical trouble, sans the entire expenses which are involved for the parties in respect of these proceedings. Going forward, I see that the arbitration in the post-pandemic era would also be more digital, it would be more virtual, and that makes it more faster and most effective. Forums in India are now developing to give a good platform for an online mechanism to conduct arbitral proceedings. Maxwell Chambers in Singapore has already developed those situations and also being easily conducted through those platforms that are available. Without taking much more time, I now don't still want to be in between this lecture, and I also want to be a student, if Professor Bond permits, to be part of this entire Uttaranchal University to only listen to you. Over to you, Professor Bond.
Thank you so much, and thanks in particular to Anna and the Dean for their very, very kind introductions. Thanks as well to the Law College and the Moot Court Society for the invitation and the opportunity to speak this afternoon, this evening to all of you. Most importantly, of course, thanks to the 293 participants. I know you have many things to attend to during this pandemic, other distractions or duties, and I appreciate your taking the time with me. It's an opportunity that I cherish, and it's a real honor. Thank you again. The topic I wanted to talk about was both the past and the future, the past of international commercial arbitration and how it compares with other forms of international dispute resolution, but then also the future. What can we expect from international arbitration in the new circumstances in which we find ourselves? Is the future winter? Is winter coming, as some have suggested about international arbitration generally, or do we see a new spring? What does the future hold? Let's begin though with international dispute resolution. We sometimes take a view that litigation, arbitration are irritants, they're unproductive, they cost money and don't build things, they don't produce constructive results. Business people, businessmen, businesswomen, I think frequently take that view. They see litigation, also arbitration, as something that is entirely negative. It doesn't add any value to either their business or indeed the commercial world more generally. That's not, in fact, true. In fact, although disputes are to be avoided, although disputes themselves don't add value to either businesses or commercial life, what we do, dispute resolution, whether by litigation or arbitration, does add value. Unless there is an effective way to resolve commercial disputes, business people won't enter into transactions in the first place. And that is particularly true in cross-border transactions where you have the uncertainties of foreign legal systems, enforcement of judgments, concern about the competence or integrity of foreign courts, the neutrality of foreign courts. All of that makes cross-border transactions particularly perilous. And as we're going to see, one of the reasons that international commercial arbitration exists, and I would suggest one of the important things that it really does contribute to life, to commercial affairs, is its ability to resolve disputes, and by resolving disputes, give businesses the confidence they require in order to enter into contracts in the first place, and in addition, provides a mechanism for solving disputes in a peaceful, in a relatively constructive way. Unless a means of dispute resolution exists, unless a reliable and effective means of dispute resolution exists, then commerce, and particularly international commerce, literally can't occur, or at a minimum can't occur effectively and efficiently the way that business people and our entire societies want it to be able to do. In that regard, international commercial arbitration was designed precisely to provide a good, indeed a better form of dispute resolution than the alternatives. And that's because of what I've in the past called the 5 E's. International arbitration is, as compared to the alternatives, more efficient, more expeditious, more expert, more even-handed, and more enforceable than the alternatives. Each one of those E's, those 5 E's, is important, and each one is related to the basic character of international arbitration. what distinguishes international arbitration from other types of dispute resolution is most importantly the parties' consent and the parties' involvement in the arbitral process, in particular, the process of selecting the arbitral tribunal. What international arbitration is and what defines it, what distinguishes it from other forms of dispute resolution is that it is a consensual means of finally resolving a commercial dispute by decision makers, non-governmental decision makers chosen by or for the parties, who afford the parties an opportunity to be heard. That definition of international commercial arbitration is found in leading treatises, it's found in national court decisions, and it really reflects the essential character, the essential nature of arbitration. It requires the parties' consent, the arbitration agreement, but it involves, most importantly, the parties' direct participation in the constitution of the arbitral tribunal, and in particular, the parties' choice of who the arbitrators for their dispute, each dispute that might arise under their arbitration agreement, will be. Often, if you have a three-person tribunal, each of the two parties will choose unilaterally one of the co-arbitrators, one of the two co-arbitrators, and then those two co-arbitrators together, or the parties together, will agree upon a presiding arbitrator, the chairperson. In some circumstances, parties will agree to institutional arbitration instead of ad hoc arbitration, and in those circumstances, if the parties are unable to agree upon the presiding arbitrator, the arbitral institution will choose her or him on behalf of the parties. The defining aspect of arbitration, which distinguishes it from other forms of dispute resolution, is the party's ability, the party's freedom to choose the arbitral tribunal in the manner that I have just described. That manner applies for a three-person tribunal, which is typically the most common form of arbitral tribunal in international commerce, but one can also have sole arbitrators, just one arbitrator, where in those circumstances, both parties have to agree upon the identity of the arbitrator, failing which, again, the arbitral tribunal will select the presiding arbitrator. Again, though, the critical feature of arbitration is that it is consensual and that the parties are directly involved in selecting the arbitral tribunal, and doing so, importantly, for each dispute that arises, doing so depending on the nature, the characteristics of a particular dispute. And as we're going to see in a couple moments, hopefully, that characteristic of arbitration, the party's ability to choose the arbitrators, to choose the arbitral tribunal, is essential to most of the 5 E's that I've discussed. The parties also have the opportunity in international arbitration to be heard, to present their case according to neutral adjudicatory procedures, which give them an opportunity to be heard. It's an essential feature of arbitration which distinguishes it from some other forms of dispute resolution. With that background, though, with that discussion of what international arbitration is, what are the 5 E's and how exactly does the nature of international arbitration prove up or contribute to each of those 5 E's? Let's start with expertise. International arbitration is more expert than other forms of dispute resolution, and in particular, more expert than its principal competition, being national court litigation. How is arbitration more expert than a national court litigation? The reason is simple when you think about it. In national court litigation, the judge or judges, we'll consider that possibility in a moment, but the judge is selected randomly, arbitrarily, without regard to typically the character of the parties or the nature of their dispute. Judges are assigned randomly in order to hopefully ensure a degree of neutrality and to eliminate the possibilities of favoritism or politically or other motivated appointments. Judges are judges of general jurisdiction. They hear all kinds of disputes. They hear commercial disputes involving every type of commercial relationship, but they also hear administrative law disputes, they hear criminal disputes, they hear tax disputes, environmental disputes, they hear domestic relations disputes, landlord-tenant disputes, employment disputes. They hear almost every conceivable type of dispute. And naturally, in those circumstances, they're jacks of all trades, but in the eyes at least of some commercial parties, masters of none. In contrast, international commercial arbitration, also investment arbitration, gives the parties the opportunity, once a dispute has arisen, to choose the arbitrators, to select those arbitrators who they believe, who they have confidence in being the best possible choices to resolve whatever the dispute is that has arisen. If the parties have a joint venture agreement involving a telecoms business in Bangladesh, they're free to pick experts who have expertise, experience in telecommunications joint ventures, who understand Bangladeshi governmental procedures and law insofar as that is relevant, and who have commercial expertise and legal expertise directly focused on the character of the parties' dispute. If the parties have an insurance coverage dispute, they can pick insurance lawyers or arbitrators with specific expertise in the type of dispute, the type of coverage dispute, whether it's pharmaceutical or high tech or some other type of industry, precisely the type of expertise that is involved in the dispute which has actually arisen between the parties. The parties have the greatest knowledge of anyone in the world as to what their dispute concerns and what types of expertise will be important in resolving their dispute in a fair and equitable manner. The parties also have more incentive than anyone else in the world to have their dispute resolved in an expert fashion. Parties sometimes, of course, play games in the appointment process, but by and large, the parties' incentives as I've described, incentives being to pick arbitrators who are more expert, who are specifically expert in resolving the type of dispute that has arisen. And as a consequence, comparing those two forms of dispute resolution, it's clear that international arbitration offers greater expertise than the alternatives, and in particular, national court litigation. That expertise is underscored by the role of arbitral institutions, professional institutions whose primary function is selecting arbitrators who have extensive experience with the performance of different individuals as arbitrators, who know what expertise particular arbitrators have and equally don't have, who know what sort of availability and what sort of diligence different arbitrators bring to the table in resolving disputes. And as a consequence, the very process of constituting the arbitral tribunal ensures that the first of the 5 E's, expertise, that I've described is realized in the arbitral process, particularly when it is compared to the alternatives. Expertise is especially important in commercial matters where businesses want their disputes to be resolved by people who understand their business and who can make decisions about who's right and who's wrong, but also decisions about what sort of relief is appropriate and constructive, with a keen knowledge, a keen awareness of the underlying commercial realities of the businesses in which the two parties are engaged. The second of the 5 E's, the second and the third of the 5 E's are related to the first, to expertise. Those 2 E's are efficiency and expedition, both of which international commercial arbitration offers. International commercial arbitration offers efficiency and expedition in part because of the parties' ability both to choose the arbitral tribunal and thus choose people who will not need to be re-educated at great expense and length of time about the underlying character of the party's business, but also choose arbitrators who are familiar with international arbitral procedures and international dispute resolution. At the same time, the parties enjoy under the New York Convention, more about that in a moment, and most national arbitration legislation, like the Uttaranchal Model Law and International Commercial Arbitration, more on that also in a moment, enjoy great procedural autonomy, the ability to tailor the arbitral procedures to the particular parties and the particular dispute that has arisen in an individual case. Instead of national court procedures, where one has lengthy volumes of civil procedure rules, one-size-fits-all rules, which apply in all cases. Instead of one-size-fits-all rules of civil procedure, international arbitration permits parties to tailor the arbitral procedures precisely to their individual dispute, their individual needs, whether it's the languages or the cultures, the commercial background that is important to the resolution of that dispute. By tailoring the procedures to the party's individual dispute, the parties in the arbitral tribunal are able to arrive at more efficient, more expeditious procedures than the alternatives. Parties also benefit from the fact that arbitration does not involve the same type of multiple layers of appellate review that exists in most national court proceedings. Rather, arbitral awards are, as the parties agree and intend, final and binding. Once the arbitral tribunal makes an award, that award resolves their dispute, finally resolves their dispute, subject to only very limited judicial oversight, scrutiny of a limited specific number of issues concerning the tribunal's jurisdiction, concerning the fairness of the arbitral procedures, concerning issues of public policy. But there is no review of the substance, the merits of the arbitral tribunal's decision in virtually all circumstances. What that means is that there are not multiple layers of re-review, reconsideration of the party's dispute by new tribunals, new layers of judicial review, all of which take substantial amounts of time, particularly in some jurisdictions, all of which take substantial amounts of money, and all of which add substantially to the uncertainty of the dispute resolution process. National courts, when you think about it, must have those layers of appellate review precisely because the national court decision maker, the first instance decision maker, is chosen arbitrarily without any regard to the experience that he or she may have. In those circumstances, the likelihood of mistakes are fairly substantial, and thus substantial layers, multiple layers of appellate review are necessary. Where the parties themselves are able to choose the arbitral tribunal based on the specific characteristics of their dispute, those layers of appellate review are neither necessary nor desired by commercial parties. What commercial parties want is speed and efficiency, which is what they get from the arbitral process because it does not involve multiple layers of judicial review. International arbitral institutions have also enhanced the efficiency of the arbitral process in the last decade by introducing expedited procedure mechanisms. These mechanisms provide that in smaller value cases, the arbitral award must be made within a specific period of time, typically 6 months. Smaller value cases of less than $2 million in the case of the ICC, 4.5 or 5 million US dollars in the case of the Singapore International Arbitration Center, will be resolved in 6 months according to a fast-track arbitral procedure. During our rules revision process at the Singapore International Arbitration Center, we consulted widely as to whether or not parties considered expedited procedure, whether businesses considered expedited procedure to be a desirable or a less desirable thing, whether they wanted greater possibilities, opportunities to have expedited procedure, or whether they wanted it to be more narrowly limited. Overwhelmingly, almost unanimously, uniformly, commercial parties said that they liked expedited procedure. They wanted more, not less of it. They wanted it available in more, not fewer cases. And again, that's because of the second and third of the 5 E's. Commercial parties desire efficient and expeditious results, dispute resolution mechanism. And when you think about the nature of commerce, you can see again why that is so. Businesses want to be able to get on with their business. They don't want to spend time mired down in national court proceedings with multiple layers of review and the inevitable uncertainty that that brings, the inevitable expense that that imposes. Parties instead want their dispute to be resolved quickly, sometimes even if that means it won't be resolved quite as well, but they want it to be resolved quickly so that they can go ahead with the business of their commercial affairs. International arbitration is also, and this is a critically important characteristic and feature of international arbitration, is also more even-handed. International arbitration is more even-handed than national court litigation precisely because of its international character. If you have an Indian party contracting with say, a US party, neither party, frankly for pretty good reasons, wants to be on its counterparty's home turf. The Indian party does not want to be in front of a US jury in Houston, Texas, or Delaware, or Los Angeles. The American party doesn't want to be in Delhi courts or Mumbai courts in front of an Indian judge. Both parties have reasons for their preference to avoid their counterparty's home turf. International arbitration avoids that risk. International arbitration permits the parties to choose a neutral arbitral seat and choose a neutral arbitral institution. In that sense, it's more even-handed. The arbitral tribunal also typically will be chaired by an arbitrator who does not have the same nationality as either of the parties. That's required by both the ICC, the SIAC, and other rules, and in many circumstances, national arbitration legislation. And thus, when the American and the Indian party contract, their future disputes need not be resolved in either the United States nor India, nor by an Indian or an American jury or judge. Instead, the Singapore International Arbitration Center can appoint a Singaporean or English or some other neutral nationality. Likewise, the ICC, seated in Paris, can appoint a neutral arbitrator, and the parties are free and frequently do choose a neutral arbitral seat to consider annulment of any arbitral award. This even-handedness contributes significantly to the efficiency and expedition of the arbitral process as well. Parties are not as suspicious about the dispute resolution process because it's even-handed and because they have a role in tailoring it, and thus they are more likely to comply with its ultimate results. And this is a critical benefit, though, the even-handedness, the neutrality, the objectivity of international arbitration as compared to the alternatives. Even-handedness is related as well to the final of the 5 E's that I've mentioned, the enforceability, the relative enforceability of international arbitration as compared to the alternatives. I mentioned previously the New York Convention. That's the shorthand for the United Nations, the UN Convention on the Recognition and Enforcement of Foreign Arbitral Awards, drafted in 1958 and today with 164 contracting parties around the world, virtually every country in the world. North Korea is an exception, but virtually every country in the world, certainly every country with any major trading aspirations, is a party to the New York Convention. The New York Convention does 2 main things. In Article 2, the New York Convention requires contracting states, all 164 contracting states, to recognize and enforce international commercial arbitration agreements. Article 2.1 and Article 2.3 do so subject to only very narrow, specifically defined exceptions. When a country accedes to the New York Convention, it promises that its courts will recognize and enforce international commercial arbitration agreements. So thus, when parties agree to arbitrate, they can, with a high degree of confidence, be certain that those agreements to arbitrate instead of litigating their disputes, will be honored. And that if their counterparty changes its mind after a dispute arises, national courts will not entertain litigation on the merits of the parties' dispute, but will instead refer the parties to arbitration. That aspect of the New York Convention, Article 2 of the New York Convention, is parallel, is mirrored by Articles 7 and 8 of the Uttaranchal Model Law, which you have in India as the Indian Arbitration and Conciliation Act 1996. It gives effect, as the national arbitration legislation in other jurisdictions give effect, to Article 2 of the New York Convention. And thus, when parties agree to arbitrate, they can be relatively certain that that agreement to arbitrate will save when the arbitration agreement is invalid based on the application of generally applicable contract law principles. That dispute will be referred to arbitration pursuant to the parties' arbitration agreement. And in that respect, the International Arbitration Agreement enjoys a significant enforceability premium as compared to other forms of dispute resolution agreements, such as, for example, choice of court clauses or forum selection clauses that provide that the parties' dispute would be resolved in a specific national court. Unlike choice of court agreements, international arbitration agreements benefit from a fully developed, essentially global international treaty, the New York Convention, that gives effect to those agreements. There is no counterpart for forum selection agreements. The Hague Choice of Court Agreements Convention has only a few contracting states, the European Union, Singapore, but I think even those states begin to question whether accession to the convention was a good thing or a bad thing. In any event, not for our lifetimes, or I suspect ever will the Choice of Courts Convention be a reasonable competitor to the New York Convention. The second thing that the New York Convention does is in Articles 3, 4, and 5. And it does, those provisions do, for international arbitral awards, the final decision of the arbitral tribunal, precisely what Article 2 does for international arbitration agreements. Namely, Articles 3, 4, and 5 require contracting states to recognize and enforce arbitral awards, subject to only a very narrow list of defined and narrowly drafted exceptions. Exceptions for a tribunal's lack of jurisdiction because there was no valid arbitration agreement, or its excessive jurisdiction because it decided disputes that were outside the scope of the arbitration agreement. Exceptions for procedural unfairness, but only gross procedural unfairness, where the parties were denied an opportunity to be heard, to present their cases to the arbitral tribunal. And finally, instances of non-arbitrability or violations of public policy, narrowly defined, applicable only in very limited circumstances to things like bankruptcy or criminal sanctions. In most civil, most commercial contexts, disputes are arbitrable, and issues of public policy do not present significant challenges, bases for significant challenges to the arbitrator's decision. And as a consequence, what the New York Convention does, implemented by the Uttaranchal Model Law and other national arbitration legislation, is makes international arbitral awards portable around the world. All 164 contracting states will recognize and enforce foreign arbitral awards. And thus, in that dispute that we had between a US and an Indian party, if the arbitral tribunal makes an award in, say, Singapore or Paris, the neutral arbitral seat chosen by the parties, that award is subject to immediate recognition and enforcement, not just in Singapore and in France, but also in 162 other countries around the world, pursuant to the terms of the New York Convention. The arbitral awards will be, in virtually all circumstances, recognized and enforced in accordance with their terms. And thus, if the Indian party prevails, it can count on US courts recognizing and enforcing the arbitral award. And should they not do so, they can count on Canadian, British, other courts around the world recognizing and enforcing the arbitral award. Once the parties have arbitrated their dispute and the arbitral tribunal has made a decision, that decision well and truly finally resolves the parties' dispute, which is, again, one of the objectives of businesses, one of the reasons that they choose arbitration, and one of the things that they desire in dispute resolution processes more generally. The ease of enforceability also contributes to the efficiency and expedition of the arbitral process. If parties know that awards will be enforced against them, they're more likely to comply with the award voluntarily, which occurs in the vast majority of arbitrations in any event. They're also more likely to settle their dispute on reasonable terms before an arbitral tribunal even needs to make an award, precisely because the parties know that the dispute will be resolved in an even-handed and enforceable manner. If that's the case, and if the tribunal is expert, the parties are more likely to take a commercially sensible view and be willing to enter into a commercially sensible resolution of their dispute. And that is, in large part, those 5 E's are in large part one of the reasons that international arbitration has been so popular in the last several decades. The number of arbitrations over the last several decades has increased almost exponentially. At the Singapore International Arbitration Center, 30 years ago or so, just in the infancy of the institution, SIAC had a caseload of literally less than a dozen cases. Today, you will have a caseload in excess of 475 cases this year in 2020, perhaps 500, one doesn't really know, but a very substantial caseload. SIAC is not alone in that. Other arbitral institutions, the ICC, ICSID, other institutions around the world have reported similar growth in caseloads. International arbitration is in many ways the natural means of dispute resolution, certainly the most popular means of dispute resolution in commercial, cross-border commercial transactions. What does that mean, though, about the future? What, in particular, does the pandemic suggest about the future? Does it pose a threat, or does it pose an opportunity for international arbitration? I think it poses an opportunity, and in that respect, I agree with Justice Nariman, who I think we've heard a précis of his views. During the pandemic, arbitral institutions, all arbitral institutions, though being competitors, have cooperated together in creating virtual hearing protocols and digitalized dispute resolution mechanisms. At the SIAC, we've remained open for business without interruption throughout the pandemic. Indeed, more requests for arbitration have been filed thus far this year, 2020, than last year, 2019, which was by a substantial margin the busiest year in SIAC history. Despite the pandemic, arguably in part because of the pandemic and the economic dislocation that it has caused, SIAC has received more requests for arbitration, more arbitrations than ever before. Emergency arbitrations have been conducted on multiple occasions over the past several months. Arbitral tribunals have been constituted to hear emergency requests for interim relief. Normal arbitrations as well have gone forward in much the same way that they did before the pandemic hit. Arbitral tribunals have conducted so-called virtual or remote hearings using exactly the kind of technology we're using here, Zoom, to hear parties, give them an opportunity to be heard, notwithstanding the absence of physical presence. Witnesses have testified. I've cross-examined a couple witnesses by Zoom and presided on arbitral tribunals in arbitral hearings where the parties' counsel were all in different locations, different countries. Nonetheless, the arbitral process has gone forward and gone forward at least as efficiently, arguably more efficiently than before the pandemic. I don't think that the way that arbitrations were conducted before the pandemic was inefficient. I think that it used the existing technology in a way that satisfied most users. But oddly, ironically, the pandemic has forced new means, new uses of technology that previously weren't exploited. I think when the pandemic ends, if it ends, and air travel, other types of transportation resume, many of the things that we do today during the pandemic will continue to be done. I conducted a case management conference just last week, where, as I mentioned previously, counsel were in different locations, France, the Netherlands, other locations around Europe. Traditionally, those types of conferences would have been conducted in person. The parties all and their advisors would have flown to some city at some expense, rented hotel rooms and a meeting room, and conducted a 3 or 4 hour case management conference. That same conference was conducted just as efficiently by Zoom. The parties had to adjust slightly to the virtual presentations, but I think, as you can tell from this presentation, as you can tell from other virtual lectures that you've heard, it's just as easy to communicate virtually as it is in person. You have to be careful in some aspects. Witness cross-examination presents particular challenges. Sharing documents requires some advanced preparation. Sometimes you need new and better technology, more screens, bigger screens, different kinds of keyboards, prearranged protocols for communicating with your team members. But all of that is doable. All of that enables much of what we did previously in person to be conducted remotely. There'll be cases, of course, where one does not want to or perhaps can't use remote technology, where parties really do want to be in the same hearing room in order to inspect exhibits, to cross-examine witnesses in person, to be able to look at the tribunal directly. I suspect that those will be fewer rather than more cases than we might anticipate. But the critical point is international arbitration will have the tools to conduct hearings and other types of proceedings in the arbitral process remotely rather than doing so in person. In a funny way, just as before the pandemic, I wouldn't have conducted this lecture for you, not just wouldn't have conducted it by Zoom, but wouldn't have conducted it at all. So with arbitral hearings, so with the international arbitral process, the pandemic creates opportunities that didn't exist before in the good old days. And finally, the question arises, what will life look like for national courts? Not just now, when many have interrupted their usual functioning in contrast to arbitration, and instead hear only very urgent matters or some other select categories of cases. What will national courts do after lockdown ends? I have little doubt that national courts will go back to their usual way of proceeding. That's particularly true in jurisdictions where a jury trial or lay judges are involved. You can't really have those types of proceedings virtually. In other jurisdictions, I think courts will naturally conduct their proceedings where else but in the courthouse, where they've always been conducted. In contrast, international arbitration will, in all cases where it's appropriate, in all cases where the 5 E's call upon it to be used, we'll use remote technology, we'll use virtual technology, and thus enable greater cost savings and greater efficiency, greater expertise to be brought to bear. All of that makes me think that it's not winter that's coming, but instead a spring. Spring is coming, spring for international arbitration, because it will be more, as it historically has been, more flexible, more adaptable, more able to adjust to new technologies, new changed circumstances. That at least is my hope, my expectation about the future, but only time will tell. And in a very real sense, only you all will tell. The 330 of you participants will tell, because the use of that technology will be in the hands of you and your generation more than anyone else. And I wish you good luck with it and trust that you will be good stewards of what the arbitral process bequeaths to you. Thank you.
Thank you very much, Professor Bond. May I speak on behalf of the 331 participants who are listening to you, it was indeed a matter of pleasure as well as privilege to have listened to this beautiful lecture. Now I request Mr. Kunal if he might like to add something on the topic.
I only want to thank Professor Bond for such an enthusiastic lecture. It's indeed heartening to see that he not only took into account that it is going to be a whole lot of students who now have the entire perspective within 40 minutes of what an international commercial arbitration would be. I'm also very glad that a seasoned arbitrator, a seasoned expert, and an experienced arbitrator like Professor Bond sees a green light, a hope at the end of the tunnel, and has enthused us to say we are now entering spring and not winter. I'm really, really grateful, Professor Bond. I have learned as your student the 5 E's, and I am going to implement those 5 E's soon. I promise that. Thank you very much for your time this evening.
Thank you.
Now, with your permission, sir, we have a few questions.
Of course.
So the first question is, what is the scope of arbitral institution liability, and is it high time for the institution to take liability during the pandemic to ensure due process apart from the arbitrators themselves, maybe in form of civil liability?
So the New York Convention doesn't address the question of liability of either arbitral institutions on the one hand or arbitral tribunals, arbitrators on the other hand. It's a question largely of national law. Most national laws do not specifically address the question of institutional liability or of arbitrator liability. That's true, for example, of the Uttaranchal model law, which I've mentioned a few times already. However, a few national laws, a few statutes do address institutional and arbitrator liability, and most national courts have had occasion to address the issue. The basic rule is to analogize arbitrators and therefore arbitral institutions to national court judges who in most jurisdictions enjoy a substantial measure of liability. The thinking is you don't want national court judges worried about their own personal liability in resolving or about their exposure to litigation in conducting the adjudicative function of resolving parties' disputes. You want them independent and unafraid of the potential of personal liability. Virtually all countries adopt that basic approach, and they also extend it to both arbitral tribunals and arbitral institutions. There are exceptions, relatively narrow exceptions, in cases of deliberate wrongdoing or malfeasance, cases of fraud or the like. But for the most part, arbitral institutions and arbitral tribunals enjoy a substantial measure of immunity from conducting their mandate, from fulfilling their mandate, conducting the functions that they're required to do pursuant to the parties' arbitration agreement and the institutional arbitration rules.
Thank you, sir. So the next question is, somebody has requested your insight on the Singapore Mediation Convention, which facilitates the enforcement of settlement agreements via mediation versus the current arbitration proceedings.
The Singapore Mediation Convention, which was signed just last year with 48 signatories, has just come into force. It doesn't have a substantial number of contracting parties as yet, I think less than half a dozen, but a substantial number of states have indicated their intention to ratify the convention. The question rightly identifies what it is that the convention does, namely makes settlement agreements arrived at through mediation or alternatively conciliation subject to enforcement, recognition and enforcement around the world. That is a good thing. It enhances international dispute resolution, and for the same reasons that arbitration facilitates international commerce, so does mediation, and the mediation convention makes settlements arrived at through mediation more portable, more enforceable. Naturally, one requires a settlement agreement. One must actually arrive at a consensual settlement through the mediation process before the convention can have its desired effect. But and that identifies actually one of the key differences between arbitration on the one hand and mediation on the other. Arbitration produces a final adjudication. Whether or not the parties both at the time the decision is made agree with that or not, arbitration, like a national court decision, involves an adjudicator, the arbitral tribunal, deciding finally the parties' dispute. Arbitration is consensual in the sense that parties must agree to arbitrate, but it's not consensual in the sense that parties don't need to agree upon the result that the arbitral tribunal reaches. Instead, once they've agreed to arbitrate, parties are bound to accept the decision of the arbitral tribunal. In contrast, mediation is merely an effort to facilitate further consent to a settlement agreement. The mediator, the conciliator, has no authority to resolve the parties' dispute. He or she simply encourages the parties to reach a negotiated settlement. And that is a key distinction between mediation and arbitration.
There's this question which says, what is the role of public policy exception in international commercial arbitration practices in India? How or whether public policy exception can be of any help in performing its performance level in the ease of doing report? What is the role of public policy exception in international commercial arbitration practices, basically?
So public policy has one very clear role in international arbitration and one less clear role. The very clear role is reflected in Article 5(2)(b) of the New York Convention and relatedly Article 36 of the Uttaranchal Model Law and the parallel provisions of the Indian Arbitration and Conciliation Act. What Article 5(2)(b) and the Model Law provide is that an award may be denied recognition, a foreign award may be denied recognition if it conflicts with the public policy of the recognizing state. So in the case of India, if a foreign arbitral award conflicted with Indian public policy, Indian courts would not be required to recognize the award, although otherwise they would be. Public policy, therefore, is a kind of escape valve. It permits a country to deny recognition to a foreign award in those unusual, exceptional cases where the award violates national public policy in the recognition forum. Virtually all courts, including Indian courts, have said that in the context of foreign arbitral awards, public policy is to be interpreted narrowly. Sometimes public policy is characterized as what some law professors describe as an unruly horse. Once you get on it, you never know where it will carry you to. It's taken from an old English decision from a couple centuries ago. In fact, under the New York Convention, public policy has been a relatively well-behaved horse, and it has stayed in a relatively narrow, confined stable, not venturing out. Most national courts, including at least some Indian courts, have treated public policy in the context of the New York Convention as what they call international public policy, as opposed to purely domestic public policy. And what's meant by that is that one takes a view of public policy with an eye towards the character of the parties' dispute resolution process and the international character of their transaction, and thus applies domestic public policy only in a restrained manner and only in those circumstances where it's absolutely essential to protect the basic and fundamental legal character, social and economic character of the recognition state. Only in the most exceptional and unusual cases will public policy be applied. Much the same approach is taken in the context of annulment as opposed to recognition under Article 34 of the Uttaranchal Model Law. I mentioned that there are two areas where public policy can be important. And I've just described the first. The second area, which is more controversial, is to what extent can public policy be invoked as a basis for denying recognition of an arbitration agreement, in particular under Article 2 of the New York Convention, Articles 7 and 8 of the Uttaranchal Model Law. Neither Article 2 nor Articles 7 and 8 refer to public policy. In that regard, they are different to Article 5.2b. And they're also different to Article 2.1 of the New York Convention, which refers to so-called non-arbitrability. Non-arbitrable subject matters or grounds to not refer the parties to arbitration. But public policy is not identified. And I think the better view, the more enlightened view by many national courts, is that you ought not to decide public policy issues at the stage of recognizing and enforcing an arbitration agreement. Instead, you should refer the parties to arbitration, allow the arbitral tribunal to address and resolve their dispute, and then, but only then, if there is a public policy objection, have it be heard in annulment or recognition proceedings.
Professor, as you mentioned, a very positive.
Professor Bond, before we proceed to the next question, there's a lot of requests in the chat box regarding the 5 E's that you have answered. People want you to repeat it for them. We have been answering them, but I think they don't believe us. So can you please repeat?
Okay, so the 5 E's: expertise, efficiency, expedition, even-handedness, and enforceability.
Thank you so much, Bob.
And if you want to look to the future, we could have a 6 E's. It would be electronic, because for all the reasons that I mentioned before, international arbitration will use virtual technology, remote technology, electronic hearings more effectively than the alternatives. Electronic is the 6D.
Thank you, Professor. So, in addition to all the plus points you mentioned with respect to arbitration in the pandemic, are there some challenges as well, in addition to the points you already mentioned, like cross-examination of witnesses and presentation of documents? There must be some additional challenges as well to arbitrate through technology.
Yeah, there certainly are, and that's a good point to raise. Two practical difficulties are particularly notable, although there are certainly others when you use remote technology. They're not insurmountable, but they're challenges that need to be managed. The first is time zones. The very fact that virtual technology allows us to communicate from around the world. I'm sitting here in London. You all are mostly in India. For all we know, we have people from Los Angeles or Singapore also on the line. Indian legal community is far flung, and thus we may have people literally from all over the world, which in the one hand is a huge benefit, but in the other hand means that inevitably people are in different time zones. And exactly the same thing is true in hearings. If you have a hearing with people from Los Angeles, New York, London, and Singapore, necessarily somebody's morning is somebody else's middle of the night. And one needs to schedule hearings with an eye towards that. And there are certain difficulties if you have sufficiently far-flung time zones. One has to accept that hearing days may therefore need to be both reduced. You can't sit a normal 6 or 8 hour day, but also readjusted. Maybe you sit 3 hours in the morning and 3 hours in the late evening instead of sitting in the middle of the day. Also, and relatedly, virtual technology creates issues of attention span. I'm sure I would have been very boring in person, but I know I'm even more boring virtually. And people will become more exhausted watching me on a television screen, on a computer display, than doing so in person. Exactly the same thing is true in hearings. You can't have an 8 hour hearing. People, arbitral tribunals, counsel, lose their attention span and have to go off and do other things. Again, that takes me back to the notion, though, that in a sense this is a double-edged sword. It's a problem because we have limited attention span, but it's also an opportunity. We see hearings, quite rightly, given their historical origins, as a single concentrated event. We will all go to Singapore for a 5-day hearing. And since we're all in Singapore, what we're going to do in that 5-day hearing is go to Maxwell Chambers every day at 8:30 and stay there every day until 6 o'clock. And then we're going to go back to our hotels and we're going to work in the evening until it's time to go to bed to wake up the next morning and go to Maxwell Chambers. It is a concentrated event where everything is focused on the hearing. With a virtual hearing, A, you can't really do that because of time zones, but B, you don't need to anymore. You can schedule your hearing in pieces over a longer or different period of time. You can have one witness one day for 3 or 4 hours, another witness the next day or the day after for 2.5 hours, some procedural discussion one evening for 1.5 hours. You can rearrange the entire chronology of hearings in ways that are suited precisely to the party's dispute. In some cases, maybe what you'll do is just what you always did. You have a 6.5-hour hearing from start to finish every single day, 5 days a week. In other cases, though, you'll be more creative and adjust things. 2 final practical points: documents, number 1, and translations, number 2. Documents are important in arbitration, especially cross-examination, also sometimes openings and closings. You want in openings and closings to be able, in some cases at least, to give the tribunal a PowerPoint, give it slides that will help them follow your presentation, will enable them to more efficiently see particular documents or charts, graphs, whatever that you want them to focus on. Virtual technology presents issues there. They can be overcome. You can share screens, you can distribute things by box or other mechanisms in advance so that people can access documents electronically, but that needs to be worked out and you need to pay attention to it because virtual technology doesn't always work as well, at least today, in sharing documents and being able to scroll through a document. This is, in a sense, seems like ministerial or sort of trivial technical issues, but it can really affect the flow of both an opening and, more importantly, a cross-examination. If you can't get the witness to the part of the document that you want to confront him with in an efficient way, your cross-examination can lose a huge amount of its efficacy. And therefore, just dealing with the practical question of presenting documents can be a real challenge. It's entirely manageable, but it needs to be managed. Likewise, translations are an issue. You can't talk over one another virtually. Only one person can talk at a time. Therefore, simultaneous translations become a challenge. You can manage that through having separate channels, but you need to take special steps to do so. You can also manage it by having consecutive instead of simultaneous translation, sequential instead of simultaneous translation. But again, it needs to be managed and planned in advance. Often with virtual hearings, it makes sense to have a tribunal secretary or the arbitral institution walk counsel, the expert witnesses, the tribunal through the technology and through all of the different features that will need to be used in advance. And in fact, that is what typically happens. You have a practice session, but it is something that needs to be attended to.
Thank you, Professor. So if now there are no further questions, I request Professor Dr. Poonam Rawat ma'am, Principal at Law College Dehradun, to deliver the vote of thanks for the evening.
Thank you, Anna. Greetings to all. It gives me immense pleasure and I'm feeling proud to propose vote of thanks on behalf of Moot Court Society of Law College Dehradun to the keynote speakers of today's evening, Professor Gary Bond, and Mr. Kunal Vajani for taking time out of their busy schedule to enlighten the future lawyers as well as other professionals on such a branch of law that is one of the fastest growing branch in the world. Is indeed an enriching experience and very insightful. My special thanks to Professor Dr. Rajesh Bahuguna, Vice Chancellor of the Uttaranchal University, for guiding us in the course of organizing this webinar. My special thanks to all the participants from all around the world, without the participation of whom this initiative and learning experience would have been incomplete. And last but not least, my special thanks to Team MCS, a special thanks to Anna Anupriya and Rahul and all the office bearers. Thank you, thank you, thank you everyone. Thank you, sir.
Thank you. Thank you, everyone.